You'd say we won the battle, but the war is still going on.
Coming up on Frontiers, the highest court in the land sided with a moose hunter, yet the end is not in sight.
There's a lot of uncertainty with what will go forward.
The complicated process of fighting the feds over land rights in Alaska.
Sponsorship for Frontiers with Rhonda McBride is provided by Kupik Corporation and Spenard Builders Supply. Alaska, where there are old triumphs, but also new frontiers, with challenges as great as the state itself, but a belief the best is yet to come, bringing you the faces, the places, and the spirit of the last frontier. This is Frontiers with Rhonda McBride.
Welcome to this follow-up Frontiers program, in which we revisit the case of an Alaska man who took his fight against the federal government all the way to the U.S. Supreme Court. The justices have weighed in, but our story doesn't stop there. It's hard to believe a moose hunter's fight to use a hovercraft in the Yukon Charlie Preserve would come to represent so many things to so many people.
Basically, standing up for what he knows is right, standing up for Alaska.
It's a classic Alaskan story.
A story of John Sturgeon's battle against the National Park Service that made it all the way to the highest court in the land. As it turned out, it would be the last case heard by Justice Antonin Scalia, with some wondering, had he lived, would Scalia have led a majority to rule in favor of Sturgeon? But the justices, in effect, decided not to decide. In a unanimous decision, they voted to send the case back to the Ninth Circuit Court.
You'd say we won the battle, but the war is still going on.
One of the main issues in the Sturgeon case, whether the Park Service could apply its lower 48 ban on hovercraft to Alaska. While the Supreme Court did not rule on that issue, Justice John Roberts spent a lot of time, in his opinion, reviewing Alaska's complicated history of land deals, such as the Alaska Native Claims Settlement Act and the Alaska National Interest Lands Conservation Act. ANILCA repeatedly recognizes that Alaska is different, Roberts wrote, from its unrivaled scenic and geological values to the unique situation of its rural residents dependent on subsistence uses to the need for development and use of Arctic resources.
I think it's interesting how narrow the decision is.
The UAA Justice Center has been following this issue.
This was a big deal to have in front of the Supreme Court.
Ryan Fortson teaches a course in tribal courts and native law.
Once you sort of open the door for reinterpretation of ANILCA, that it could have impacts that go beyond what the parties intend. And so it could end up negatively impacting subsistence.
Which is why the Native American Rights Fund filed an amicus or friend of the court brief siding with the Park Service to protect the landmark Katie John decision, which affirmed her right to fish on the Copper River under a federal subsistence priority. Although John Sturgeon's case was not about subsistence rights, there were worries a court victory could undermine the John decision.
You answer one question, and more questions pop up as a result of the answers to that first question.
While tribal groups sided with the Park Service, two Native corporations sided with Sturgeon.
So he was putting his hovercraft in the Yukon Riverhead Eagle and coming down.
Sturgeon was piloting his hovercraft near land Doyon had set aside for oil and gas exploration.
If the Ninth Circuit's decision had held, it would definitely have impacted our ability to do exploration.
Doyon says the justices were right to send the decision back to the lower court because its ruling was too broad.
We have a very complicated set of statutes and a very complicated land pattern in the state.
In his job as CEO of Doyon, Aaron Schutt constantly refers to the land deals of the past and must navigate their complexity.
I guess it's like when you're trying to navigate the Yukon River in the fog.
Schutt says the justices' main message: understand the 49th state's unique history.
We think it was a strong signal to the other courts, the Ninth Circuit and the District Court in this case, but also future courts, to take care and understand why and how the statutes and rules were crafted.
Under the Native Claims Settlement Act, Doyon received about 12 million acres, most of which is used for fishing, hunting, and gathering firewood.
Here you're on Village Corp land, and you're back on Doyon land, and you're back on the refuge. It's a great big puzzle for sure.
A puzzle that is still being worked out.
National parks are incredibly important to this country.
Jim Adams is head of the Alaska branch of the National Parks Conservation Association. The watchdog group's mission to protect national parks.
It seems like common sense that the National Park Service, and thus Americans, would have some voice in how those rivers are managed.
Adams agrees the Ninth Circuit Court overreached.
Mr. Sturgeon brought a case about rivers, but the Ninth Circuit decision was broad enough that it began to implicate a lot of other people's inholdings interests.
Adams wonders if the court's ruling might be an opportunity.
It was a do-over, basically.
Since the court's decision, there's one thing everyone involved agrees upon. The battle is likely to go on for a long time, and the legal bills will only grow and grow. At this point, it's probably worth going back to January to hear the lively debate inside the Washington, D.C. courtroom where the Supreme Court justices heard the case. KTVA's Emily Carlson was there and says there was lots of confusion.
We'll hear argument next in Case 14-1209, Sturgeon versus Frost. Mr. Findley?
Thank you.
John Sturgeon's attorney, Matt Findley, spoke for just 32 seconds before.
Mr. Findley, can I ask just two very quick clarifying questions, just so I understand what's at issue here?
The justices were stern and sometimes harsh.
You're reading on a practical basis with respect to the navigable waters. Makes almost no sense to me.
If it had said that, no private lands shall be subject to the regulations applicable to public lands, you wouldn't be here. You would have won your case already. But it doesn't say that.
But one of the justices had trouble digesting the case.
I just thought this case is too complicated to ask anything, but you've tempted me.
Justice Breyer appeared confused twice.
I shouldn't have gotten into it. It's too complicated. Skip the question.
But Justice Kagan wasn't confused. Her line of questioning was pretty clear.
That seems to me a very strange thing that Congress would have created federal lands in a federal parkland, but said that the Federal Park Service can't have anything to do with the rivers. The rivers are like an important part of the park, aren't they?
Then it was the federal government's turn. Rachel Kovner argued the National Park Service can regulate rivers and even private land inside national parks.
And so, for example, if the Park Service regulates some activity on private lands that is going to cause danger or harm to the system units that adjoins them, that's the only circumstance in which authority to regulate private
Danger or harm, is that what it's limited to? Or could it be limited to scenic, environmental, noise impacts?
We think it's clear that the Park Service can't simply treat inholdings as though they were public lands.
Then Matt Findley had the last word.
They're relying on the Organic Act, which allows them to enact any regulations they feel necessary at any time.
And after an hour of questioning, it was over.
Thank you.
Thank you, counsel.
Reporting for Frontiers, I'm Emily Carlson.
It's all a reminder of how those in charge of deciding what happens in Alaska rarely have an intimate knowledge of our state. Well, John Sturgeon and his attorney Matt Findley join us to talk about where this ongoing turf war goes from here.
We have a story of 27 families that put 18 months of their lives into building a village, a home for themselves and their future. Our Inupiaq culture goes back thousands of years, carried by a strong sense of community. Our relationship with our natural surroundings is at the heart of our culture. By investing in future generations through development that is balanced with the love of our land, the Kupi Corporation brings together traditions of the past with visions of the future.
At Spenard Builder Supply, we know it takes a lot of ingredients to get it just right. That's why we have design centers in every store to personalize the most important rooms in your home. We'll help you select cabinets, faucets, and appliances that fit your style. So all you have to worry about is how much oregano goes in Mom's pasta sauce. Spenard Builder Supply. Building for life.
Now offering financing with no payments or interest for 12 months. Visit our design experts today at your local Spenard Builder Supply.
Air travel for Frontiers is provided by Pen Air. When business or recreation takes you anywhere across the state, Pen Air is there. The only family-owned airline serving Alaska. Pen Air, the spirit of Alaska.
When I first came up here, I was told about stories. Tell me a story, and how important it was to tell the stories here in Alaska. And it's true. Highlights matter, but you got to tell stories about people. That's ultimately what it is.
There's an old saying, everybody complains about the weather, though nobody does anything about it. Well, you can't blame a guy for trying. We know you can't change the weather, but you can change the way you look at it. And while you can study all the models you want, eventually, you're gonna have to go outside. Carlos Fora and KTVA 11 weather. Be there.
Before we talk with John Sturgeon and his attorney, we thought a timeline on this case might be helpful because it spans nearly a decade. Well, it all began in 2007 when park rangers told Sturgeon he could not operate his hovercraft on the Nation River in the Yukon-Charlie National Preserve. Sturgeon filed a lawsuit against the Park Service and several federal officials. In 2013, the U.S. District Court for the District of Alaska ruled in favor of the National Park Service, so Sturgeon appealed. But that decision was upheld in 2014 when Sturgeon lost to the Ninth Circuit Court of Appeals. Then the U.S. Supreme Court agreed to hear the case, which they did in January of this year. And last month, the U.S. Supreme Court unanimously decided to overturn the case, sending it back to the lower court. So here we are, starting another chapter in an ongoing saga. We have John Sturgeon here, the heart of the case, and his attorney, Matt Finley. So I guess the one thing that people always wonder about, John, given that the court didn't specifically rule on your issue, is do you consider this a victory?
Absolutely. I think that the decision is very far-ranging, and I think that the Supreme Court justices were playing the long game, that they were looking at Alaska as making clear that the federal agencies and everybody knew that Alaska was different, and they went to great lengths to say that when a federal government does things in Alaska, they need to remember that Alaska is different. We have laws, ANILCA, and the Native Claims Settlement Act, and other laws that make Alaska different. And I think the court did a very good job of pointing it out and directed the lower courts that they need to take that into consideration very strongly before they make any decisions about Alaska.
Well, let's go back to Justice Roberts' opinion, in which he emphasizes repeatedly that Alaska is different. And we'll just let these scroll. Matt, as you talk about this, I mean, to say that Alaska is different, by God, we know that. We are different. But why was it so important for him to continually repeat this?
Well, there are several reasons, and I think it's, first of all, though, it's important to notice, while Justice Roberts gets credit for writing a very fine opinion, this is the opinion of a unanimous court, and so this is also the opinion of Justice Kagan, Justice Ginsburg, everyone across the bench, and that's very significant. And, you know, it's important to recognize that we who live up here understand Alaska is different, but that's because we're here, we've seen it, many people haven't. And one of the things that both myself and the state lawyer, Ruth Botstein, who argued on behalf of the state, was there to educate this court a little bit, who's never been here, to educate how different Alaska is. So to have a unanimous opinion from the Supreme Court making clear, yes, Alaska is different. The statute says that, Congress says that, the circumstances are different. It provides guidance to every court going forward on how to address land use issues in Alaska.
So who was this message worded for the Ninth Circuit?
The message is, the message is worded for the Ninth Circuit. It's worded for all of the district court judges. It's worded for all the federal agencies. It's worded for all the state agencies. I mean, anyone who's going to touch land use issues in Alaska, this opinion provides guidance on how they should be resolved. And so in that sense, this opinion goes way beyond even what happens in this particular case.
So, John, I guess a lot of people are wondering, is there anything else that can be done besides going back to the drawing board? Maybe some court settlement?
That's a possibility. We have not been approached by the federal government. We'd certainly entertain talking to them as long as we can get our issue settled. But so far, we've not had any contact by the federal government that they want to settle anything.
There's something about your case that touches on all sorts of other issues. People's anger about wanting to build a road in King Cove to Cold Bay. So many other issues where it's popularly termed federal overreach. Why is that, do you think, that your case seems to bring it all together?
Well, I think one of the reasons, I guess, is we made it all the way to Supreme Court, which brings a lot of attention to the case. And I think that as we went through the case, it became a lot more than just a hovercraft, obviously. It became a state sovereignty issue. It became making sure that the federal government kept the promises they made in Anilka, the promises they made to Alaska Native corporations, and that the promises they made that Alaska's non-federal lands would be available for development. That was kind of the great compromise in Anilka. So I think it hit hit with the kind of the average person that sees a lot of federal overreach in Alaska, and that the federal government, at least in a lot of people's opinion, and mine included, that they really don't listen to the little guy very much. And this is a case where the little guy got to say with the federal government.
Well, so at the outset of this, what were you told about suing? What would happen to you?
Well, part of the process before you can file a lawsuit, you have to exhaust all your administrative appeals. And we started at the lowest level of the Park Service and worked our way up. But we were told that by one of the Park Service employees that got a little frustrated that we would had a very difficult time suing the federal government, that they had a building full of attorneys, that they had unlimited dollars, and that we would quickly run out of money before we got anywhere down the road to sue the federal government. And it's something that just wasn't possible for us to do. And it was kind of a spiteful response, but we took it in stride and moved on anyway.
So having been told that, why did you go forward?
The only thing I can think is probably low IQ. But I've been in the resource business my whole life. I've been in the timber industry, and I've personally observed a lot of federal overreach. I've observed a lot of times where the federal government has not listened to the public. And I think that was just the point in my life where I said, somebody's got to do something about this, and I'm going to try. I wasn't sure how successful I'd be, but somebody's got to stand up and say something, and I decided to do that, and fortunately I had really a lot of help. So it's not something I did by myself. I had a lot of help from a lot of people.
Well, Matt, it's not every day that someone gets to argue before the Supreme Court. And I just have to ask you this. He interrupts you. You're interrupted just within minutes of starting, not even a minute.
Yeah, less than that. I mean, one of the things the U.S. Supreme Court is known for is they're what's called an active bench, and they will ask you questions almost right off the bat. And so what happened in this hearing is fairly typical. Matter of fact, we had a bet, sort of informal bet amongst the lawyers working on the case, how many sentences I'd get in before I was asked the first question. I had 2 sentences, and I won the bet.
This is a hearing that went roughly an hour.
Yes.
Not a lot of time to talk about, 50, 60, 70 years of history.
No, not at all. And, for all the preparation that goes into it, that time goes like that. You start talking, and all of a sudden you realize you're done, and you have about, 70 points you still want to make.
And so what point are you going to keep making going forward?
I think the key point in this case, and what this case has always been about, is going back to the statute Congress passed in 1979 in Anilka and abiding by the various compromises that were made in that statute, where the idea was to resolve a lot of land claims disputes. It wasn't just about what land is going to be national parks, it's about what land the state selects under the Statehood Act, and it's also about resolving land selections under the Native Claims Settlement Act. One of the key compromises that was done was, okay, you're going to create all of these Anilka parks, but any land that's going to be within these parks that's owned by the state, owned by the native corporations, or owned by private parties isn't going to be a part of the park and isn't going to be subject to park regulation. And so the important emphasis is that's what Congress is doing. That's the compromise that was made to create all of these national parks, which has created some benefits, but there was also benefits on the other side of the ledger, and that comes in the beginning of the statute, tells you that this is a dual purpose statute.
Right.
So it's important to emphasize that.
That it
going
was
forward.
a promise.
Yeah, exactly.
That's how it's been characterized. Well, let's talk a little bit about going forward, because if it's punted back to the Ninth Circuit, that's, you told us, John, you've already spent around $700,000, more than that, to defend this case. How do you keep going with that?
Well, it's probably even a bigger story than going to the Supreme Court is the incredible support I've gotten from all Alaskans, from all walks of life, from the Alaska Outdoor Council, Native corporations, Safari Club International, individual people sending $5 to $10. It's just been incredible support from Alaska. In fact, from the very beginning, the first day it was a newspaper, I got a call from Ed Rasmussen, a good friend that I've hunted and fished with, and he said, John, I believe in this cause, I'm going to help you. And Ed has been with me since the very beginning, and he's going to be with me to the very end. So a lot of ways that we've got to give him credit. He's been my partner, kind of a silent partner all the way through this. But just generally, Alaskans have been extremely supportive. We had a fundraiser in Fairbanks that Senator Murkowski attended and was kind of the MC, and we raised $67,000 in about 15 minutes for the lawsuit. And I'm confident we'll continue on to raise money because people feel very strongly about this case because it represents so many different things. ANILCA, the promises of ANILCA, state sovereignty, federal overreach. And so I'm not too concerned about it. People have been very generous, and I'm sure they're going to continue to be generous helping me fund this case, because I can't do it by myself.
Well, narrowly, your issue is about driving a hovercraft on a river that the Park Service says it should have control over. But yet you could hunt for moose using a boat. You could reach that area with an airplane. So, I mean, why keep going? I mean, why was this such a big deal to you?
I think it was just the principle of it. Like I said, I've been in the resource development business my whole career, and I saw a lot of examples of federal overreach and the federal government making promises that they didn't keep. The Congress telling them to do something and they find a way around it. And I think it was just, this was kind of a tipping point where I said, somebody's got to stand up and do something. And I think with a lot of help, I've been able to do that.
Well, this case was historic in many ways, but also it involved Justice Scalia. It was his last case. Had he lived, do you think there might have been a different outcome, that this 8 unanimous vote arrived because they didn't want to split court?
It's really hard to tell. It's certainly possible. If he was around, he may have seen a 5-4 decision doing something else. You really don't know, and they certainly didn't tell us before they came out with the opinion. But I think one of the important things to keep in mind about the issues that they sent back to the lower court is none of these issues had been decided by the district court or the Ninth Circuit in the first instance. And the U.S. Supreme Court often says in its opinions they're a court of last review, not a court of first review. So it's not a surprise at all in some ways that they sent these issues back, and folks shouldn't read too much into that. And that same thing could have happened with Justice Scalia there. You just simply don't know. I think what is significant is getting a unanimous opinion from them, not only reversing the Ninth Circuit and reversing an interpretation that obviously across the spectrum the U.S. Supreme Court thought was unreasonable. To have a unanimous opinion saying this things about Alaska is just very significant. And so I think rather than focusing on what maybe could have been, it's important to focus on what we have.
So you have assumed almost hero status in Alaska in some groups. How do you feel about that?
Well, it's pretty humbling, but like I said, the bigger story is how much help I've had, and I think I represent a lot of frustrated people across Alaska that are frustrated with the federal government not keeping its promises, frustrated with what they call federal overreach. And so I think that's the bigger story, is that I think I represent a lot of frustrated people in Alaska and organizations.
That's a big load to carry on your shoulders.
It is at times, believe me, it is. It's a little more than a hovercraft hunting moose. It's grown into a little bit more than that.
All right, well, I want to thank both of you for joining us, Matt Finley, John Sturgeon's attorney, and John Sturgeon for bringing us up to date. We are going to carry this conversation on the web, so be sure and watch the Web Extra for more. And coming up, springtime in Alaska, a little early this year, rousting some out of hibernation. Up next, we'll show you wildlife on the move.
The Alaska Native Tribal Health Consortium provides comprehensive health services for Alaska Native and American Indian people across our state. In addition to world-class care at the Alaska Native Medical Center, our work delivers health services for rural Alaska. From cutting-edge technology for the best care possible, to modern construction of clean water systems and health clinics, to health training and outreach that honors our culture, our vision is that Alaska Native people are the healthiest people in the world.
I thought I was the only person who didn't know how to drink appropriately.
Alcohol was a best friend for years, and eventually it stopped doing that.
I just knew I had to quit. I needed to be there for my children.
My day one was May 22nd.
My day one was...
Day one for me. My day one.
My day one.
Day one.
My day one was September 29th, 2009.
So they say it's a man's world? I don't see anybody's name on it.
While they were doing their thing, we slowly changed our world.
Today, women can do anything men can do. And there's one thing we're even better at.
Now, when this fire roared to life yesterday around 1 p.m., it took a lot of people by surprise.
That's where I like to be. I like to be where things are happening, where people are. That's just how I am. I just don't want to sit around behind a desk. I mean, I think it's important to actually be out there telling the stories from where the stories are happening. We're about exceptional journalism, and I think we've really proved that. I think we're working hard every single day to achieve that, and that's what you're going to get.
Spring in Alaska. By all accounts, it appears that we are ahead. Trees already have buds. Southeast Alaska hit a record 71 degrees this week in Klawock, and it appears animals are coming out of hibernation early. Roy Corral took this photo of a bear near the Campbell Creek Science Center. Roy, who gives workshops on photographing wildlife, caught this sow starting to wake up. Looks like she wants to go back to sleep again. Well, always great to see old friends passing through. We want to thank a viewer from Southeast Alaska for snapping photos of these whales. We posted a photo gallery online on the Frontier section of KTVA.com. Alaska, where our abundant wildlife sets us apart, something that's appreciated around the world. But despite that, our complicated history of land use is not well understood. Well, we hope that this week's program brought some of this to light. Thanks for joining us. We'll see you next week.